Hello and welcome to this Doughty Street webinar dealing with issues of mental capacity and immigration. My name is Zoe Harper and I'm presenting today with my colleague Leonie Hirst. Both of us are barristers in the immigration team and in the Court of Protection team at Doughty Street Chambers and practice across both areas. Before we start, just a few things on the tech, which I'm sure you've heard before in many other seminars. Everyone is on mute with their video cameras off, and that's just to stop any background noise or interference. We're looking forward to your questions and comments and perspectives, and we'd ask that you put those in the Q&A function because it just makes it easier for us as panelists to pick those up. And we'll also be recording this webinar today, and a copy of both the webinar and the slide presentation will be available on the website soon after we finish for you or any colleagues who are unable to join us. So to start off, I'll just give a brief overview of what we're going to cover today. The seminar is going to focus on the crossover areas of immigration and mental capacity and court of protection. This is a developing area of practice, and so it's not a seminar where we will present the law and set out clear answers of what can be done in practice. We're finding that each case, because it's an emerging area of practice, involves problem solving around the individual case, because often those paths and processes and pathways aren't there in practice, and we're developing them as we go. And in the absence of those pathways, we know that the most vulnerable clients risk falling through the gaps. And so today we're going to reflect on some of the gaps we've seen in practice and our process of resolving those in practice. And we hope that this will help in providing awareness of some of the issues that might arise and confidence in knowing that if you've not found guidance, that's because there isn't any, and also in identifying issues and dealing with those. Joining us today, we have a mix of court of protection practitioners and immigration specialists, each working in their own area. And so necessarily there will be some areas of the talk where we're kind of giving an overview of concepts, basic concepts in each area in order to provide a basis of understanding across the different areas. But we hope that that by interspersing the case studies and reflecting on the crossovers between those areas of practice all the way through, we'll reach those areas of intersection most efficiently. So today we're going to reflect on those crossover areas through 3 different case studies, raising different issues that we've seen in practice. They're fictionalized composite case studies to allow us to discuss some of those issues. There will be many other areas of practice where those crossover issues arise, but we'll focus today on some basic concepts of identifying immigration issues and assessing capacity, practical issues around regularising status for people with mental capacity issues, and then the discrete topic of something that is seen in the case law and court of protection work around immigration and spousal applications for people where there are questions around capacity. We've not covered participation issues in immigration tribunals because that's more of an immigration specific issue, but it is an area where as immigration practitioners we see issues of capacity come up fairly frequently. Although there isn't formal guidance, there is some more kind of pathways and processes that have developed, and it's certainly something that we see and can advise upon. So To start off, I'll start by discussing the first case study and some basic concepts around immigration and mental capacity. And then Leonie will cover the second and third case studies, and before then allowing some time for questions and comments and perspectives from participants. So I'll just move straight on then to the first case study, which focuses on identifying immigration issues and assessing capacity. So to read briefly, Mr. Saleh is a failed asylum seeker from Afghanistan. His asylum claim was refused and finally determined. He has acute symptoms of psychosis, spent periods of homelessness in the UK, and was detained under Section 3 of the Mental Health Act following attendance at A&E. Whilst detained, Mr. Saleh said he was tired of being homeless and should just go back to Afghanistan. A capacity assessment was undertaken, and the health and social care teams considered that he had no entitlements in the UK, would be released to street homelessness, and in the circumstances had the capacity to make the decision to return. That case study raises a number of issues, but in order to unpack that, it's going to be helpful to take you through some fairly basic concepts in each area to then deal with the crossover. So to start with some very, very basics in terms of immigration, for the benefit of COP practitioners, and again, this is COP practitioners may well be aware of this, but it's just to kind of give a bit of a basis. That broadly speaking, people who are not British citizens or otherwise have the right of abode in the UK require leave to enter or remain, that is permission to enter or remain in the UK. And that's given in different ways, different types of leave to enter or remain. So indefinite leave to remain, which is provides the right to live in the UK permanently with no time limits or restrictions, which of all the types of leave to remain is the most secure, but bearing that in mind, it can be lost in certain circumstances, particularly where a deportation arises through criminal offending. It is where that's most commonly seen. Leave to enter or remain can also be granted for a time limited period. So the time limit may be 12 months, 30 months, 5 years. It may be subject to conditions. Some people have conditions with certain types of leave with no recourse to public funds, others don't. And it's also important to be aware that some types of leave can be extended, and it's necessary to apply to extend leave before leave expires, and there are various application forms, fee waivers to consider. And we raise this in particular because we have come across cases where a person's leave has expired whilst they've been under a period of a section under the Mental Health Act, and so it's also important to be aware that leave may be time limited. Many people on short periods of leave will be on a route, a formal route, at the end of which a person can apply for settlement, that is indefinite stay without conditions, but some routes are longer than others, and it's also possible to fall off that route if leave isn't extended. Some types of leave don't lead to route of settlement. You can see it all gets a little bit complicated. For EEA nationals, there used to be the parallel system of EU citizenship laws under which EEA nationals and their family members had rights that were derived through that parallel EU regime that applied directly in the UK. Of course, as a result of Brexit, there have been significant changes, and now EEA nationals need to apply for leave to enter remain under the domestic scheme, and so for people who were living in the UK up until Brexit Day. There's a particular scheme, the EU settlement scheme, under which people apply to regularise their stay because of Brexit, and Leonie will talk a little more about that. The other type of permission that people might have is immigration bail, and that's not a form of leave, but it's a type of temporary permission to be admitted whilst a person's status is being examined, and so asylum seekers, for example, will be on immigration bail. A person's immigration status has significant consequences. Different status have different rights and entitlements, and also not having status also has very significant consequences. Indeed, a person may be liable to removal in particular, but also may be subject to the hostile environment, which restricts access to free secondary healthcare, including community mental health provisions, and access to welfare, mainstream welfare benefits. So really important then to have an awareness that of sort of immigration status and entitlements. For people who have no leave to remain or insecure leave to remain, or whose status is uncertain, immigration practitioners will look at a range of possible applications that may apply to an individual to look to regularise their stay. And on the slide, I've put just a few groupings of types of considerations that an immigration practitioner might look at. So there may be protection-based claims based on risks on return, and that those risks on return may include risks arising from somebody's mental health condition, as well as any reasons why a person came to the UK originally. That might be a first asylum claim. It could possibly be a fresh asylum claim after a claim has been determined. There may be private life or family life applications that can be made based on length of residence in the UK, significant obstacles to integration if returned, dependency on family members, a range of circumstances that may be weighed against the public interest generally of applying immigration control measures. EEA related applications are also quite a wide area, because the definition of family members under EU law has been very wide, and those definitions have been included in settlement scheme categories as well. So the non-EEA family members of EEA nationals can be quite a wide pool, and also people may have citizenship through their parentage, their childhood in the UK, other types of ancestries. It's a very, very complex area, but an immigration practitioner will look across a whole range of possible applications to consider how to regularise someone's stay. On the other side, for immigration practitioners, it's really helpful to have a kind of a working understanding of the Mental Capacity Act. The Mental Capacity Act is different from the Mental Health Act 1983. The Mental Health Act 1983 applies if someone has a mental health problem, and that sets out when someone risks detention because of that mental health problem, i.e. section, and the rights when they are sectioned under that act. In contrast, the Mental Capacity Act 2005 applies where someone has a mental health problem and it's necessary to identify if they have the capacity to take a particular decision and what happens when they don't have the capacity to make that decision. So in the very simplest terms, that's the difference between the two acts. It's Section 1 of the Mental Capacity Act sets out the fundamental statutory principles of that act, and I've set those out on the slide just there. I mean, in summary, that these apply to the whole act, and the focus of the act is about empowering people to make decisions and presuming capacity, taking steps to support a person to make their own decisions rather than taking them for them wherever possible, and this empowering approach is to avoid discriminating against people with disabilities and assisting people to make decisions themselves as far as possible. The test for lack of capacity is found at sections 2 and 3 of the Mental Capacity Act and expanded further in the Code of Practice. And both these sections of the Mental Capacity Act and the Code of Practice are really accessible, so really worth reading through. Section 2.1 sets out the test, which is set out there in the second bullet point of the slide. And that test requires two elements, both diagnostic and functional. So in order to consider whether a person is unable to make a decision for themselves, Section 3 of the Mental Capacity Act goes through 4 key issues to consider when assessing if a person is unable to make a decision. So they need to understand the information relevant to the decision, retain that information in order to be able to make a decision, use or weigh that information as part of the process, and communicate that decision. And the inability to make a decision following that framework must be because of an impairment or disturbance in the functioning of the mind, and that therein brings in the diagnostic element of the test, and that may be for a range of different conditions, including mental illness, learning disability, but also things like drug or alcohol use. That the decision is in relation to the matter, and therefore it's decision specific. It means that if you have capacity to make one kind of decision in your life, it doesn't necessarily mean that you have the capacity to make another type of decision. And indeed, a person's capacity might change over time, or at different periods of the day, or different periods of time. And then when a person lacks capacity, the Mental Capacity Act then discusses how a decision may be taken in their best interests, and how to determine what is in their best interests and how that process is arrived at. So in terms of assessing capacity, of course, the Mental Capacity Act presumes capacity, and normally as practitioners, we would presume capacity unless anything suggests otherwise. And so one might consider capacity, for example, when there are particular triggers like unwise decisions or any particular triggers for concern. In terms of who should assess, this depends on the nature of the decision to be made. In terms of legal transactions, it's the legal practitioner who assesses initially whether a person has capacity to give instructions, because of course the legal representative will know the relevant information against which a person's capacity would need to be assessed, or in terms of knowing whether they have litigation capacity. However, it will usually be necessary to obtain clinical advice on the diagnostic element, and so it's very common for us as practitioners to sort of spell out to a specialist clinician, a psychiatrist, what the type of information that a person would need to know and be able to use weigh in order to have capacity, and then for the psychiatrist to provide clinical advice on their view of the person's ability to do each of those steps. It's important that all practical steps are taken to help P to make a decision, again from that empowering approach, and the point around the information that's relevant to the decision. It's really important to be aware of what is the relevant information that's necessary to make the decision. And in that context, the Court of Protection case law kind of explains that you don't start with a blank page. The protected party needs to sort of have detail of the range of options and assistance in setting those out in order to be able to weigh those up. So returning to the case study, as I said, that raised a number of issues. First of all, around entitlements. So, for example, when somebody's released from section, they are entitled to continuing care under Section 117 of the Mental Health Act 1983, and this is a provision that isn't subject, or at least is exempt from the normal NHS charging regulations. There are also other Care Act duties that apply, and indeed in this case, in the slide, the individual actually had a pending fresh claim, and so they would have had alternative entitlements under Immigration Act provisions. So in this case, there hadn't been involvement by the authorities of the solicitors involved in his claim, and that's particularly important in terms of having relevant information in order to provide advice. So in this case, if someone had a fresh claim, it may have been that there was fresh evidence, for example, of the risk to them in Afghanistan, new documents, but also there are things that may have changed since the previous claim. So the individual might not have been unwell at the time that his previous case was heard, and there's case law around the risk to people with mental health difficulties in Afghanistan because of the stigma and discrimination people face. There are also questions around lack of treatment, as well as the sort of treatment of people with mental disability. A lack of treatment can also give rise to protection issues there. So in terms of the case study messages to COP practitioners, is that it's important not to make assumptions around what someone's status is or might be. That status may change. It may change on account of a mental health difficulty, and it's always important to involve an immigration specialist and not make assumptions either about a person's status or their entitlements. There's also perhaps a different culture in the two areas of practice, in the sense that as a public body, the Home Office does not necessarily act in a person's best interests. It's a public body that enforces immigration control, and also public authorities have increasingly been required to become partners in enforcing immigration control through the hostile environment. And also many authorities have provided the safety net provision when mainstream benefits and entitlements have been removed, and so under resource pressures. And so immigration practitioners are kind of often picking up on where clients have fallen through the gaps, and so and also it may be that authorities are unaware of a person's full entitlements as well. For immigration practitioners, perhaps one of the messages from this case study is that capacity assessments depend on the information on which capacity is assessed, and so it's important to review assessments quite carefully to consider how capacity was assessed, as well as the outcome of that assessment, and also to be aware that there will be community care entitlements to support beyond the traditional kind of immigration entitlements to support that perhaps we're more familiar with. So I'll now move over to Leonie, who's going to present on the second case study.
Thank you. Can you flip the slide?
Right.
I hope everyone can hear me. It's chucking it down here, so hopefully you won't be drowned out by, I won't be drowned out by the rain. So this is this part of the presentation is really to talk about an area where we think there's going to be particular problems in the next few months, and that is EEA nationals. But a lot of what I'm going to say applies equally to regularising status for non-EEA nationals. So this is a classic kind of situation where you have an EEA national who's been living in the UK for a long time, and he's currently in local authority care. He's got no family, but he's got a friend who comes to visit him, and his friend is concerned about him and whether he can be made to leave the UK against his wishes. So we'll come to the issues again at the end, but a lot of this section is going to be about what powers the Court of Protection has to help protect someone in S's situation. Next slide. So these are the powers of the Court of Protection that are relevant in, or can be relevant in, immigration cases. And the first one is section 16, which is sometimes described as the court's core jurisdiction. So this is the power to make decisions on behalf of someone who lacks capacity, or to appoint a deputy to do so. And there are two main clusters of decision-making types that the court can make. One is welfare, and that is decisions about where P should live, what persons P should have contact with, things like that, sort of issues to do with P's well-being. Property and affairs is pretty much what it says on the tin. Property is very much physical property, money, financial affairs. Affairs can include legal arrangements, so they're non-exhaustive definitions, but they do indicate what kind of area you're in. Immigration status is not referred to in the Act, and it's a bit unclear whether it's a welfare issue or a property and affairs issue. And I think it will depend a bit on what kind of immigration status we're talking about, and what the consequences are of P not having a particular immigration status or not making an application. It's really important to remember that the Court of Protection can only make decisions under section 16 which are available to P. So the Court of Protection obviously can't make any decisions about immigration status. It can't force the Home Office to make any decisions about immigration status. All it can do is take decisions that P could take, such as whether or not to make an application, whether or not to lodge an appeal, whether or not to seek to regularise status, whether or not to make an application for someone else to join P. And that's a really important limitation on the court's powers. The court has the power also under section 15 to make declarations, and those declarations are whether P has capacity to make a specific decision, or the lawfulness of an act or decision taken on behalf of P. And that can be an act that has been taken or an act that is proposed to be taken. It's probably right that we mention LPAs. They're unlikely to be relevant to many of the cases that we deal with in immigration, but basically an LPA allows someone who has capacity to authorise someone else to make decisions on their behalf should they lose capacity. But the LPA has to be made when someone has capacity to do so. So by the time that someone has lost capacity, if there is no LPA already made, it will be too late to have one made. But so it's worth being aware that is out there. But again, the power of attorney will only extend to the powers that are included in by the donor. Next slide. Deputyship is a really important part of the court's core jurisdiction, and is the ability to authorise someone to take decisions on behalf of P. The court has to consider whether a deputy is actually needed, and there's some suggestion that welfare deputies are limited to only the most serious cases and the most difficult cases, but actually it's very rare, I think, that the court will decline a deputy in cases where immigration is involved, which will have where a failure to make a decision or a lack of someone to make a decision on P's behalf will have really dire consequences. It's a separate application process to seeking an order under the under Section 16, and so there can sometimes be questions about timing and how urgently a decision is needed on P's behalf. But generally, the powers of the deputy are limited to those specified by the court, and usually what happens is an order is drafted setting out the powers to be given to the deputy. That can be time limited, and it can be also purpose limited, so it's possible to appoint a deputy for the specific purpose of making an application on P's behalf, or for managing P's immigration affairs for a specific time, or they can be indefinite. Who can be appointed as a deputy? Well, anyone. The list at the bottom of that page: spouse, partner, relative, close friend, professional advisor, local authority, panel deputy. That's a list of persons who can act in order of preference by the court. So if there is a spouse or partner who can act, then their appointment is to be preferred to a professional panel deputy. The deputy must obviously act in P's best interests, and a failure to do so may lead to the court revoking the powers of the deputy. And the deputy has to consult P and permit and encourage him or her to participate as fully as possible in the decision process. Litigation capacity. So Zoe talked earlier about the capacity test, and the same test is effectively being applied for litigation capacity. But the question is, when you're considering litigation capacity, particularly whether P can understand the issues in the proceedings, can give instructions on those particular issues to enable him or herself to be represented, and whether he or she can understand advice and make decisions based on it. And again, it's always going to be context specific. So if P may well have the ability to litigate in a very straightforward money claim, but not to make a complex asylum claim involving issues of humanitarian protection and disputed evidence. So it's always going to be context specific. And again, the primary person who decides whether P has litigation capacity is P's legal representative. Next slide. When P does lack litigation capacity, someone will need to act on behalf of P to conduct proceedings. This is all, hopefully should all be fairly straightforward. In civil proceedings, the relevant part is Part 21. Court of Protection, it's dealt with in Part 17 of the Court of Protection rules. There's no formal procedure, as Zoe mentioned earlier, in the first tier tribunal or the upper tribunal for appointing a litigation friend, but the court is able to do so, and that leads to a rather ad hoc procedure where the onus is on the legal representative usually to try and find a litigation friend who can act appropriately. Some types of litigation friend can act without a court order. That includes a deputy. So where a deputy has been appointed with specific powers to conduct, for example, immigration appeal on behalf of P, then that deputy can simply be authorised to act in the tribunal without any need for a court to make a decision. And the official solicitor will always be able to act without a court order. If someone needs a court order, then what needs to be done is to file a certificate of suitability and follow the procedure in the relevant set of rules. And the official solicitor is generally the litigation friend of last resort. So if there is someone else who can act suitably, competently in P's best interests, then they should be appointed. Next slide. So what happens for EU nationals, and why are EU nationals in a particularly difficult position? Well, we've obviously left the EU, and what happens now is two things. One is that EEA nationals who were not previously subject to immigration control have become subject to immigration control, which means that they now need leave to remain in the UK. And The other thing that has happened, which is very significant, is that EU nationals didn't previously need to have rights conferred on them by the UK government. They had rights which accrued to them automatically by operation of EU law. We have shifted from that system, which is called a declaratory system, to one where the only rights that you have as an EU national, the only immigration status that you have as an EU national, is one conferred on you upon application by the UK government. So if you don't make an application, even if you had pre-existing rights or pre-existing status, if you fail to make an application by the 30th of June of this year, you will no longer, at least in theory, have immigration status in the UK. And your position then becomes potentially very precarious. So the EU settlement scheme is the scheme by which the UK has given effect to the citizens' rights portion of the withdrawal agreement. And it is absolutely essential that EU nationals make an application by the 30th of June 2021. That's the cut-off date. There is a query about whether people who lack capacity, who are not able to make an application on their behalf by that date, will have a reasonable excuse and be able to make an application later on. But my strong advice certainly is that it should not be left that late. We don't want to bank on the Home Office's goodwill or the application of the sort of reasonable excuse policy. Next slide. So the application process is relatively straightforward. The problem, and the reason why we're addressing it in this seminar, is that it requires the EU national to make an application. So whereas before someone who had exercised treaty rights in the UK would have the right to remain without needing to make any kind of application and could not thereafter be removed without great difficulty, now it requires positive independent action on the behalf of the applicant. And of course, where someone lacks mental capacity to make a decision about their immigration status, and particularly where there are either learning disabilities or mental illness, there are going to be significant barriers for people not only to make the application, but even to be aware about the need to make one. And there is some, frankly, quite concerning research done by Age UK suggesting that there are 131,000 EU nationals over 65. 7% of the population in the UK has dementia. So there's an estimated 7,700 EU citizens over the age of 65 who are likely to have some difficulties accessing the scheme. And there are real significant problems because it's very difficult for legal representatives, for local authorities to find people, to identify who is likely to have the need to make an application. And then there are problems with ensuring that people have access to making an application under the scheme, that they have representation, both legal representation and also an advocate if they lack capacity. And there will also be significant difficulties with evidence gathering. So the obstacles to this particular segment of the population making an application are quite high, quite severe. The consequences of not making an application are also potentially very grave. So because EU nationals are now subject to immigration control, they also become subject to the hostile environment provisions, which Zoe was talking about earlier. And what that potentially means is that for someone who may have lived here for a very, very long time, have worked, paid taxes, settled here, lived their life here for a long time, who is now in receipt of local authority care and support, including, let's say, domiciliary care or care in a care home, they are potentially no longer going to be eligible for that if they don't make an application in time. So it's really important that both that these applicants are identified and that they're assisted to make an application. But it also is an issue which really illustrates, I think, the gap between the separate frameworks of immigration advice and representation and access to the tribunal and the court of protection framework, and the way in which people can fall between the gaps actually quite easily through no fault of their own. So people in this situation have not failed to renew their visa. They've simply, through operation of law and through Brexit, suddenly found themselves in a situation where they are going to potentially have quite serious problems. Next slide. So what happens to Mr. S? So Mr. S may or may not have status. He may previously have had a right of permanent residence in the UK, particularly if he's been previously working. He will almost certainly be entitled to pre-settled status. He almost certainly, if he's been in the care home for more than 5 years, be entitled to settled status under the EU settlement scheme. So he has a right which he can assert if someone assists him to do it. But of course, it's very unlikely, given the beliefs he's expressing about his government and the fact that he's in a care home, there are obvious concerns about his capacity to make a decision about his immigration status. It may well be that he has capacity, but it's certainly going to need someone to think about whether he can make that application himself. And if he doesn't have capacity, who can make that application for him? So it may well be that his friend C is willing to act for him informally. There might well be concerns on the part of any legal representative that he needs to have more formal representation, so there will need to be an application for a deputyship, or the official solicitor may need to become involved. The government guidance to local authorities on what should happen in this kind of case is almost no help at all. So what the Home Office guidance says is simply, there's going to be problems. Yes, either he's got a deputy who can already act, or an LPA, or some appropriate third party is going to need to be appointed. And of course, that begs the question, who is the appropriate third party? So there are going to be some really difficult decisions about trying to find people who can act as litigation friends to make the application, how that is going to be authorised. And there will almost certainly need to be applications made to the Court of Protection for both for a capacity declaration as to whether S can make a decision about his status, and a best interest declaration about whether an application will need to be made under the EU settlement scheme. And of course, timing is of the essence here. So there are going to be real issues, given that the deadline is the end of June, either with putting in place a deputy or with making sure that applications are made in a timely manner and the decisions are obtained. So those are all, at the moment, slightly uncharted waters, but it's a real illustration of the problems that can arise when someone desperately needs a decision on immigration status as soon as possible. Next slide. Okay. So the third area we wanted to talk about was marriage and sexual relations, partly because it's, at least judging by the case law, it's an area where the immigration capacity crossover can really bite. And this is a kind of classic case where you have a British citizen who has a learning disability, may have other physical disabilities, has some local authority involvement, but is basically living with and cared for by parents. There's been an arranged marriage. P is very happy about this. And now advice is being sought from the immigration solicitor about potential partners' visa application. So there's obvious issues set out there, and we're going to just look at how those should be approached by the immigration solicitor and what else might need to happen. So, capacity to consent to marriage. The good news is it's not a high threshold. There has been a lot of very vexed case law, both in relation to marriage and in relation to, particularly in relation to capacity to consent to sexual relations, which I won't trouble you with. You can spend literally hours going through it. These are the basic principles as they currently stand. I think JB is currently on appeal, so we'll see where that goes. But in essence, both decisions are not about getting married to or having sex with a particular person. They are about the nature of the act itself. So with regard to marriage, what's required is that someone has to understand what a marriage is, that there are normally thought to be duties and responsibilities attached to marriage. You're expected to care for your spouse and they're expected to care for you, that spouses have a particularly strong bond, that there may be financial consequences of getting married, that spouses share their home, their bed, generally share their possessions and their lives together, and that it's expected to be an enduring contract. When thinking about marriage, P has to have capacity to consent to sexual relations. What's not relevant are potential immigration issues. So when we're thinking about Anna, it's not relevant. She doesn't have to understand that Boris is not a British national and that him coming over to marry her may be difficult for him or require an application to the Home Office. Capacity to consent to sexual relations, again, it is issue specific, act specific rather than person specific. So what has to be understood is the rather boring phrase, the sexual nature and character of sexual intercourse and the mechanics of the act. And that is usually described in all the case law that I've seen so far as a heterosexual act, but of course it doesn't need to be. The issue is the same when it's a same-sex relationship. The fact that consent of the other person is required when sexual relations are had. The fact that P themselves should be able to give or withhold consent to sexual relations. So it's really important that P understands that he or she can say no or say yes, and that's up to them. Pregnancy is a foreseeable consequence of sexual intercourse between a man and a woman, but not the risks or difficulties of having a baby and bringing it up. So it's simply that one might become pregnant as a result of having sex. And last but not least, the health risks, potentially STIs, and the fact that those can be, the risk can be mitigated through the use of condoms. So what happens if someone lacks capacity to consent to sexual relations and as a result lacks capacity to consent to marriage? Well, there is the ability to seek a forced marriage protection order from the family court. Forced marriage is a very loaded term, but it applies simply where a party lacks capacity to consent to marriage. So there will be scenarios, or there may be scenarios, as with Anna, whereas in fact there's no force in the sense that we'd normally understand it, in that Anna is quite happy, she's very excited, she's looking forward to marriage. But if she doesn't have capacity, as it's understood in the law, to consent to that marriage, then this will be a forced marriage, and an order can be sought to prevent it before it's taken place. Next slide. What happens, or what can happen if a marriage has already taken place, is that an order can be sought outside the Mental Capacity Act, rather a declaration that the marriage is invalid. It's important to remember we've been talking about capacity and the court of protection and the general statutory framework in the Mental Capacity Act, but there will be capacity issues that arise that are not within the remit of the Act, and that can be in a range of ways. So the first is where people lack capacity, so they meet the functional element of the test under the Mental Capacity Act, but not the diagnostic element. So it may be that they are living in fear of violence from an adult son, and that's the case in DL, and that therefore their decision-making ability is impaired, not because they have a disturbance in their brain, but simply because they're scared. And again, you might be seeking a remedy that's not available under the Mental Capacity Act 2005, and a declaration that a marriage already undertaken is invalid is a specific declaration that's not available under Section 15. In the Dr. A case, it was forcible feeding of a man detained under the Mental Health Act, so where you would not normally be able to obtain a declaration under the Act. So it will also apply to other vulnerable adults, some of whom may in fact have capacity, but where they are unable to take care of themselves for a variety of reasons. So it's a broad jurisdiction, and it has survived the enactment of the Mental Capacity Act. And it's important just to remember that that is still there through the High Court, and may be something that arises in immigration cases, particularly through kinds of cases that you're likely to see in marriage and sexual relations. Next slide. So what happens with Anna? Does Anna have capacity to instruct an immigration solicitor? Potentially, she might do. The fact that she has limited ability to communicate might mean that the solicitor needs to take particular care to ensure that she's been assisted to make decisions as much as practicable. There may be particular ways that she finds it easier to communicate and particular ways that she needs to be communicated with. If she doesn't have capacity, Anna's parents may be able to act on her behalf. And again, that will take you back into either a deputyship. There's unlikely to be an LPA here, but there might be, so it's something to consider. Or a declaration and order from the Court of Protection about the specific issue of the immigration application. But of course, there's not just the issue about whether she has capacity to deal with the immigration matters. There's the question about whether this is an application that can properly be made. And if Anna doesn't have capacity to consent to marriage and sexual relations, then the marriage that is going to take place or is proposed is going to be an unlawful one. It's going to be a forced marriage. And that will need to be obviously explored very sensitively with Anna and her family if she doesn't have capacity. And if necessary, then a forced marriage prevention order would need to be sought. Anna, obviously not unhappy in this scenario or distressed. She's looking forward to the marriage and she's excited about it. But in fact, if she doesn't have capacity to consent to the marriage, then actually in this case, her wishes and feelings are not going to, they're neither here nor there. And unfortunately, that again will need to be dealt with very, very sensitively. So this scenario is looking at a marriage which is proposed to take place in the UK. The Court of Protection's jurisdiction is limited to England and Wales. And so if the marriage either is going to take place abroad or is going to take or has already taken place abroad, then there's a limited amount that the Court of Protection can do within the Act. What can be sought is an order and declaration that removal of Anna for the purposes of the marriage will be unlawful. If the marriage has already taken place, then an application would need to be made under the inherent jurisdiction to declare that marriage invalid on the basis of lack of consent. But if the intention is that Anna and Boris will get married and then live in Illyria, there isn't actually very much that the Court of Protection or the High Court can do to return her, and that can lead to some very, very vexed situations because we're not a signatory to the Hague Convention on Vulnerable Adults. So some steps are clearly going to need to be taken by the immigration solicitor, both to assess whether Anna's got capacity, to understand more about what's actually happened, whether Anna has capacity to consent to the marriage. There might need to be some communication with Anna's social worker about the kinds of support that she's got, what the local authority knows, and then someone, whether it's the local authority on Anna's behalf or Anna's parents, acting as litigation friend, potential conflict of interest, or someone else, the official solicitor, is going to need to make an application to the Court of Protection for declarations and orders all over the place as to capacity and the lawfulness of what's proposed. So that again is a sort of whistle-stop tour. This is based on the case of KA and illustrates a lot of the problems that can arise or the issues that can arise when we're looking at marriage and the crossover between immigration and capacity. Next slide. I think that's it. So I hope that's been useful, and I think Zoe's going to now talk about some ideas that we've had about how to improve things.
So one of the things we discussed is just how important it is to develop those working links between us as practitioners across Court of Protection and immigration work, and the same across solicitors. Because both areas are huge areas in themselves and very specialist. And there are also restrictions on who can give immigration advice, which is very heavily regulated. If we were having this seminar under normal circumstances, we would finish with drinks and encourage everyone to network and make those links. But unfortunately, we can't do that today. But one suggestion, if those links aren't already in place locally, is that because we work across both areas, our clerks kind of know solicitors in each areas and have agreed that they can assist in putting people in touch. So if you do need to make a referral, that's one way of identifying potential partner organisations and solicitors across the different areas, and their contact details at the back of this slide. And so, oh, I've frozen. I don't know if you can hear me, but I just wanted to end with any questions or perspectives. A couple have come in whilst we've been talking. So a court of protection colleague has asked, what is the hostile environment? It's not a detention centre, although that is, we would see that as a hostile environment too. But when we talk about the hostile environment, we're referring to the changes brought about by the 2014 and 2016 Immigration Acts, which aimed to make life in the UK as hostile for people as possible without leave, in order to encourage them to leave the country without immigration having to get involved in doing that. And so there were restrictions on working, making it illegal to undertake work, restrictions on opening bank accounts, operating bank accounts, having a driving license, on accessing secondary healthcare, and a number of other restrictions, for example, being able to rent accommodation without permission from the Home Office, all of which are aimed at making life as difficult as possible for people who don't have leave. And it does make life very difficult, not just for them, but also people who do have leave, because as I explained, that immigration is very complex, and there's a lack of awareness of different statuses and documents. An immigration colleague has flagged that where someone is under section, it can be very difficult to obtain health records, which we as immigration practitioners need to access, and I would certainly agree with that. I found that a complaint through their kind of data access mechanisms can help release. But of course, the other point that the colleague makes is that the first tier tribunal can be very anxious to get cases heard through the system, through the appeal system, without being familiar with the kind of the hurdles and barriers around capacity in having the case heard, and how important it is to ensure case management review hearings so that those issues are flagged up. And again, certainly agree with that. And she flags that lockdown makes it even harder to prepare, and particularly, I would add, because of access to health services and the pressures on them. And and another point about, I suppose, a link to the case study is health and social care staff not necessarily knowing the processes around appeals and decisions, and perhaps accepting that somebody might be removed or deported if they're told this, but not understanding that that person has a right of appeal, and they have a pending appeal, and really important that as practitioners that we're helping them understand that, so that that's factored in. She's also flagged other litigation friends that she's used, school head teacher, youth worker. And I would also add, in the immigration context, there's a really great organisation called Migrants Organise that sort of set up especially to deal with those issues, and I've found them really helpful, and really at the sort of leading edge of understanding that interface between capacity and immigration.
There's been a couple of questions about appointing litigation friends before the tribunal. So the issue with the first tier and upper tribunals is not that they can't appoint a litigation friend, it's that there's no formal process in the procedurals for doing that. So the way in which you do it in both the FTT and the upper tribunal is legal representatives will need to identify someone who can act, and it doesn't need to be a professional in any way. It can be a family member or it can be a friend. All that's required is that someone can conduct proceedings competently and in P's best interests and doesn't have any conflict of interest. And then what would need to happen is, usually at a case management hearing, an application would need to be made for an order appointing that person as formally as the litigation friend, and of course the tribunal can do that within its inherent case management powers. So that's how it works in the FTT and upper tribunal. In questions of determining suitability, again, it's really an issue of common sense, and it may be that you appoint one litigation friend informally to deal with the initial process of making the application, and then as matters proceed, it becomes clear that that person can't act competently or has got a conflict of interest, and then you need to find someone else. So it's really primarily a matter for the solicitor, and certainly I have myself, where I've acted on a pro bono basis, done some rather ad hoc appointments of litigation friends, and kind of, right, you're here, you can formally act. I wouldn't advise doing that, but sometimes obviously there's a duty to act in the client's best interest, and sometimes that's going to involve needing to move faster than a formal procedure will allow. There's another question about HD and whether that's changed the test for sexual relations and consent, and the short answer is no, and it's simply re-emphasised the need for re-emphasised the nature of the test is act specific or issue specific rather than person specific. So it's not a question of whether you are going to have sex with this person in particular, it's generally whether you understand what sex means. What else have we got? We've had a question about someone who's developed dementia and is applying for an extension of leave. I think that it would depend a bit on what you mean by wife and family members supporting the application, because technically someone will need to have authority to act on his behalf. If the application was begun before the client developed dementia, then you may be in a different position. But you're never going to be criticised for applying to the Court of Protection, and I would seek a declaration from the Court of Protection as to lack of capacity, and probably make a parallel deputyship application for one of the family members to act with specific powers to make decisions about the immigration application and to represent or to act as a litigation friend in any subsequent appeal. What else have we got? Yeah, similar question about whether you can act informally on someone's behalf. It is a really difficult area, because clearly the mechanisms that are available for a court to appoint a litigation friend or for a deputy to be appointed are very formal. They involve you already being at the stage of court, and they can take a long time. So I think the waiting time for a deputyship application is currently several months. But it's obviously very different when you are contemplating acting for P in an immigration appeal, to when you are having an initial consultation with someone who you think may lack capacity. And really, at that stage, what's really important is, as a solicitor, that you record any concerns that you have about capacity. You record any steps that you've taken to check whether your client has litigation capacity, can understand your advice, can give instructions, understands what's going on. And if you have concerns that they don't, then you need to take some steps to ensure that they are properly represented by a litigation friend. And that doesn't need to be at a stage where you're not yet in proceedings. It doesn't need to be a formal court-appointed litigation friend, but there needs to be someone who can act properly on behalf of P. And a question on the case study 3 about Anna and when a forced marriage order, or rather whose instructions would be acted on. So it's a really good question. I think that the way that should properly the route through that is, first of all, to discuss concerns with Anna and her family, obviously, to say, it appears to me that Anna doesn't have the capacity to consent to sex, and that therefore this marriage is going to be unlawful. That potentially will make Boris liable for, criminally liable. He'll be committing a sexual offence, and it will make the marriage unlawful. And you need to get them to stop the proposed marriage if you're sure that Anna doesn't have capacity. If the family won't do that, then you're going to need to give serious thought to making a safeguarding referral to the local authority, basically, because Anna will be at risk of the forced marriage if there's no willingness by the family to engage with your advice. And it is a very delicate area, and I would strongly suggest that you get ethical advice and probably counsel's advice on how to proceed before you do it, because every case is going to be slightly different. But certainly where Anna already has local authority involvement, it will be slightly easier in that the local authority should be aware of the family's situation and of Anna's particular care needs and possibly her lack of capacity as well. I had a question about ALRs. I think they are being used. So that's the accredited legal representative. I'm seeing them more and more, certainly for initial applications. And then I think by the time councils are structured, they're normally the official solicitor has taken over. But I think that is being used, although that may be more in the south. But I've certainly done some northern applications recently, and in Wales. So I think, thank you very much for all your questions. I think unless they want to add anything, we are officially out of time. I hope that you all found that useful, and obviously Zoe and I are always happy to answer questions, and I hope that you'll all think about sending your details to the clerks, because we're very keen to get this referral network set up and to try and bridge some of the gaps that exist between two separate but related areas of practice. So thank you very much everyone for coming, and we look forward to seeing you at some point in person when lockdown eases. So is there anything you want to add?
No, nothing to add. I've just put up the contact details of our clerks and ourselves on the screen here, and thank you everyone for attending.